too. Don't worry. If it messes up, we're going to go on Facebook and say it's Tyler's phone.
Yeah, maybe.
Good evening. We'll try that again. Good evening. All right, that's a little better. I'm going to ask you if you would start making your way to your seats wherever you want to sit. There's a good view from everywhere. And I want to welcome you to the Jacksonville State University Canyon Center for the Judicial Candidates Debate. And my name's Danny Lee. You may have heard me on radio before. I also pastor at a church. And I'm here in association with the Southern Torch tonight and proud to be a part of this forum. A little nervous tonight. It's been a while since I've been a part of a political forum. I'm not as nervous as the time that I went and visited a little church member at the nursing home. And she was one of these that was just kind of hard to deal with. And I went in and I noticed on the table, well, there we go. I noticed on the table there was a bowl of peanuts. And so just out of nervous habit, I started eating those peanuts and eating them. And we would talk a little bit. And finally, I looked down and the bowl was empty. And I said, ma'am, I'm so sorry I ate every one of your peanuts. She said, don't worry about it. At my age, all I can do is suck the chocolate off of them. So, but I have a unique combination of jobs working in radio and serving in a church. And you see all kinds of strange things at church. One Sunday at the invitation time, a man came up and he said, Pastor, I want you to pray for my hearing. And I said, okay. And I put one hand on his head over near his ear and just prayed over it and prayed over it. There we go. We'll get this working eventually. And after I finished praying, I backed up and I said real quietly, how's your hearing? He said, I don't know. I'm not due in court till next Wednesday. So, this is the Judicial Circuit Candidate Forum. And in just a few moments, we're going to have the opportunity to hear from all three candidates who would like to be your next circuit judge. One of them will be. And legal matters are so important. They're very crucial to our area. And you need a judge that cares, but also cares about the law. An example of that, a gentleman one time was arrested by a game warden. He killed a little egret. And they took him into court, and the judge said, sir, why did you kill this egret? And he said, well, my family is hungry. I had to feed them. And so the judge listened to the case, and finally he said, well, if that's the situation, you can go on home, we'll drop the charges. And before the man left the courtroom, the judge thought, hey, wait a minute. What did you think about the egret when you ate it? He said, well, it's a little tough. He said, it's not as bad as a spotted owl, but it's a lot worse than a bald eagle. But this is a serious event tonight, and not every day do you get to hear from judges. We hear from a lot of other candidates, plus we'll have the opportunity next week, if you're not aware of it. Looking forward to that. The Republican Primary Candidates Forum is going to be at the City Hall Auditorium in Fort Payne at 6 o'clock next week. We would encourage you to be there. But our judicial system is the foundation of what makes our country great and what makes our nation great. It's crucially important on a local level And that's why we're here, to give you an opportunity to be able to listen. And when you look to Scripture, you see that God set up a judicial system for the children of Israel. We see in the book of Deuteronomy chapter 16, beginning in verse 18, he says, "Appoint judges and officials for each of your tribes in every town the Lord your God is giving you, and they shall judge the people fairly. Do not pervert justice or show partiality. Do not accept a bribe, for a bribe blinds the eyes of the wise and twists the words of the innocent. Follow justice and justice alone, so that you may live and possess the land the Lord your God is giving you." So I believe as a voter in this area, that if it's important to God, it's important to me. And that's why we're here tonight. The series of this event also brings up some rules. First of all, I would ask you, everyone's got a cell phone. I've already set mine on silent. Either set it on silent or turn it off. If you've got to call Mama or Aunt Susie or whatever, go out in the foyer and do that, but try not to be talking or texting. No videoing allowed tonight. Southern Torch is going to be taping this, broadcasting this on the internet, and that is your opportunity. You can go back and watch it and take care of that. No audio recordings if you would. You can take a few pictures here and there, a couple of snapshots, but I would ask, turn the flash off. Don't blind the candidates, because it's going to be stressful enough up there for them. Be respectful of every candidate. I believe we've got 3 good gentlemen here vying for this position. Be respectful of them. And the other thing, no applause. There'll be 2 opportunities that you'll have to applaud. That's at the beginning, and that's at the end of the forum. So with that in mind, we're going to start this thing in just a minute. There are a few more refreshments. We've got, Nick, what about 2 minutes? 2 minutes. So about 2 minutes left. Any questions for me? Like, how'd you get so good looking? How do you keep that boyhood childish figure? Anything. Well, I appreciate you being here. This is a great crowd, and I know you're interested in what is going to be said tonight, and we're looking forward to hearing from these candidates. So just make sure your cell phone is off and you're ready to roll, and we're going to go live here in just about a minute. All right? Very good.
Danny.
Good evening and welcome to the Judicial Candidates Forum here this evening. It's going to be a great evening. I don't know if that's me or one of the candidates, but we'll resolve that difficulty here in just a moment. A great crowd here at the JSU Canyon Center. We appreciate them allowing us to be here. We also want to welcome those who are watching live on the web, those who will be watching later at their own convenience. We want to thank you for being a part of this Judicial Candidate Forum. And one of these 3 men will be the next circuit judge. So listen to their responses carefully as you watch. And as instructed, the crowd will not be applauding until at the very beginning. They'll also applaud at the very end. We want to thank the DeKalb County Republican Party for bringing this to you this evening. Southern Torch, what a great job they have done putting this together. And we want to welcome, this is one of your 2 opportunities to applaud this evening. So make it count. We want to welcome, in an order that was chosen by paper, rocks, and scissors here just a moment ago, our candidates in that order. First of all, Scott Lloyd. Our second candidate this evening, Jeff McCurdy. And finally, our last candidate this evening, Andrew Hairston. And at this time, I'm going to ask His Honor, Judge Jonathan Bell, if he would come and lead us in a word of prayer. Following that, His Honor, Judge Jeremy Taylor will lead us in the Pledge of Allegiance.
If you will, let us pray. Heavenly Father, we want to thank you, Lord, for allowing us to come into your presence. And we know we have access to the throne of grace because your Son, Jesus Christ, died on the cross for our sin and gave us access to that. And God, we pray for these candidates, Lord. We pray that you give them the courage, the strength, and the calmness and serenity to get not only through tonight, but to get through this campaign. We thank you for putting us in a country, Lord, where we're allowed to vote and elect our leaders, God. And we thank you, Lord, most of all, for the supreme sacrifice your Son made on the cross. And we pray that everybody receives Christ as their Savior. Thank you, Lord. Forgive us of our sins. In Jesus' name, amen.
Amen.
All right, if you would stand, please, and face the flag. Salute, pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And as I called out the order just a moment ago, we will ask the first round of questions in that order, and then we'll rotate from there on out. Again, welcome, and candidates, are you ready?
Yes, sir.
All right. We will begin with Scott Lloyd, and this question will be for all three, so you will have this opportunity. But the first question this evening is less of a question and more of this. Tell us a little bit about yourself.
Can I ask a,
Yes.
the flyer that went around said there would be opening statements. Are we still doing that?
This. Oh, okay. Go ahead with your opening
Okay, all right,
statement,
great,
then, if y'all are ready for
thank you,
that.
thank you.
John did not mention that.
All right, thank you. Good evening. I'm Scott Lloyd, and I would like to be your next circuit judge. I would like to thank Southern Torch for putting this forum on so that the voters can find out more about the candidates. And I would like to thank Reverend Lee for being our moderator this evening. I'm proud to be standing up here with two other candidates who are friends of mine. And we're not going to be ugly with each other this evening because we are friends, and we're going to continue working together for the next 20 or more years, and we need to continue to be friends. In this race, we're running to replace Judge Randell Cole. Judge Cole is a Democrat, and all three of us are Republicans. The reason why that's important is that means the seat is going to be flipped to the Republican Party, and I'm very proud to announce that for our party. When Judge Cole goes out, I can say that there is going to be an issue for the community because we're going to be losing 44 years of judicial experience. And even though he's a Democrat and I haven't always agreed with his decisions in my cases, I can say that 44 years of experience is something you can't just replace easily. So what I'm asking voters to do is replace him with the candidate who has the most legal experience. Again, I'm proud to be standing here with two candidates who are friends of mine, but if you look at experience, in many ways, the three of us share common values. We're all conservative Republicans, we're all Christians, we're all pro-life and pro-Second Amendment. But there's one area where one candidate stands out, and that's experience. My friend Jeff McCurdy has about 8 years of legal experience. My friend Andrew Hairston has about 5.5 years of legal experience. I have about 22. I have about 8.5 years more than all of the candidates have combined. And in a judge, experience is very important. Your judge should be an experienced legal candidate. I stand before you as a son of DeKalb County, educated in the DeKalb County school system. I also stand before you as a longtime resident of Cherokee County, with my children enrolled in the Cherokee County school system. I'm the candidate who understands the concerns of both of the counties because I'm the product of both of the counties. When you go to the polls on June 5th, I urge you to consider experience, and I would like to ask for your vote and your support because our two counties need and deserve the best qualified, most experienced candidate to be the next circuit judge. Thank you.
Thank you. Jeff McCurdy, you're up.
My name's Jeff McCurdy. I'm a candidate for Circuit Judge Place 2. As Scott said, that is to replace Judge Randell Cole. He's leaving after 44 years of experience on the bench. I'm a resident of Henniger. I was born and raised there in that community. I'm also a city councilman of Henniger at this time. I've been there since 2016. This is the first time that I've actually ran in a big race, I guess you would say. I was unopposed for the city council, so I didn't really have to run for that seat. I was a teacher for 12 and a half years in the DeKalb County school systems before becoming a lawyer. So I don't have the background that my opponents have, because they went straight out of undergrad into law school and into their career. So I've had 2 careers in that span of time. I went to Birmingham School of Law for 4.5 years. I drove 3 nights a week for 4.5 years to get my law degree. Passed the bar April 2010. Started my practice with 4 clients, and we built that practice to over 1,000 clients at this time. We have a lot of issues in this community. Like I said, I grew up here, I went to Sylvania, so I know what our community needs. I don't like it that we're called Meth Mountain. I don't know anybody that would like that, but they know that everywhere. Okay, that's sad. I don't want us to be known as that. I want us to be known as a good place to raise your family. I believe that we need to have more intervention with our kids in the school system. If we show them what drugs do to them, what it does to their lives, we may change some of their perspectives on drugs. A lot of them just think it's a fun time. You're going to go have a good time on Saturday night. They don't understand the repercussions. And I believe we can do some things about that. If I'm elected as your next circuit judge, I'll be fair, I'll be efficient, and I'll be conservative. And what that means is I'll follow the law. The law that's written is what will be put through my courtroom. Okay, I'm not up here to make the law or change the law. I would appreciate your support on June the 5th. I ask for your vote on June the 5th. And again, Jeff McCurdy, thank you.
And Andrew Hairston. Andrew Hairston, you're up next then.
Thank you, Danny. Good afternoon. Thank y'all so much for being here. I know when you wake up in the mornings, you can't wait to hear politicians speak to you. But this is an important race. This is something that, I think I'm going in and out there. This is something that hasn't happened in 44 years, place 2 in the 9th Judicial Circuit being open. I'm Andrew Hairston, and I do want to be your next circuit judge. And I think there's several reasons why this race is important. One, we've got a drug abuse epidemic that's out of control in our county. Our police officers are doing everything that they can, but it's not enough. We put them in jail, they get out. You put them in jail, they get out. That has to stop. That has to stop. We've also got to get people that are addicted to drugs real help. I think the faith-based community can play a big help in that, because when God changed my heart, my habits changed. And I think the same is true with anyone. And the faith-based, the summit here in Fort Payne had 3 graduates last week, 2 weeks ago, I'm sorry. Think of the generations that have changed their kids and their kids' kids and their kids' kids because they got clean. And it took a faith-based program to do that. That's where my heart is. That's where it's been. And we're going to improve the relationship between those and the judges in the court system. I grew up right here, a mile down the road. My dad is here. Tonight we grew up on a goat farm. He taught me how to work hard. And my mom taught me that a person's soul is more important than the clothes they wear, the house they live in, or the car that they drive. And I wish my mom was here tonight to be with my daddy and to be here and see this. I know she would be proud, but I'll see her again one day, and I look forward to that. But wanted to recognize my wife, Jessie, and our baby, AJ, probably the youngest campaigner in the history of DeKalb County. But if he's not with us, I don't get to see him, so he's here tonight. Jessie, thank you for loving me for who I am and for always working with me. She's made over 15,000 cookies. If you've had her cookies, you know she hit 15,000 this weekend. And so I look forward to getting to know you tonight and you getting to know me tonight. I'm an open book. I look forward to these questions, and thank y'all so much for being interested enough in this very important seat to be here.
All right, thank you, candidates. And we'll pose this question first to Jeff McCurdy, and then Andrew and Scott finally. There's always a discussion in politics of why a candidate runs as a Democrat or Republican, especially in judicial races. Please explain why you chose the Republican Party and what makes you a Republican.
Well, I grew up in a Republican family. With the name McCurdy in DeKalb County, you didn't have much of a choice. But that's not why I'm a Republican. I'm a Republican because of conservative values. I'm pro-life, I'm pro the Second Amendment, I'm pro the Constitution, and I believe that makes you a Republican. If you look at the things that's going on in the world today, in our country, it's unbelievable at some of the things that get pushed on us by the opposite side. And as conservatives, we have to push back, okay? And places like Alabama and DeKalb County, I believe that shows that we are sticking to our conservative roots and our conservative values. And I've been a lifelong Republican. I've never been anything else but a Republican. Every candidate that every campaign that I've went for has been Republican. I started voting in 1990. And ever since then, I voted Republican. And so I think it's my conservative upbringing, my conservative values. Like I said, I'm pro-choice, I'm pro-Second Amendment. But other than that, I'm pro the Constitution. I believe what it says. I don't believe that I'm supposed to write words into it. I don't believe I'm supposed to take it on a different level than it's not written. And so I believe that that's what makes me a Republican.
And Andrew, I would pose the same question to you.
I became a Republican when I was 16 years old. I didn't grow up in a real political household. My dad was a police officer. My mom was a school teacher. And we didn't really talk politics that much. To be honest with you, I didn't know what a Democrat or Republican, the difference between them, when I was 16 years old. But we had to do a history research paper. Coach Boatwright, Jeff Boatwright at Fort Payne High School, and I came across Ronald Reagan's speech for Barry Goldwater titled A Time for Choosing. And in that, President Reagan spoke about the freedom of the individual. He spoke about how we as free people in America know better how to live our lives than the government knows how to live it for us. I know how to raise my child better than some politician in Washington, D.C. knows how to raise him for me. And so at that time, watching that video, I said, well, if Ronald Reagan's a Republican, then Andrew Hairston's a Republican. And as I grow up and as I learn fiscal responsibility and you start paying attention to those things, conservative values work. They've been proven over time to work. And so every time I approach an issue, I approach it from, I'm a free person in this country, and that's something that people have fought, bled, died for. And as that, I think we can live our lives better than the government telling us how to live those. And so I was proud at 16 to become a Republican. I joined the DeKalb County Young Republicans, Judge Jonathan Bell and myself. Judge Bell was the president, I was the vice president. I later became the vice president of the Northeast Alabama Young Republicans, which incorporated Cherokee County and Marshall County and Jackson County into the mix. And been a Republican ever since.
All right, thank you. And Scott Lloyd.
I'm running as a Republican because I am a Republican. I've been a Republican my whole life. I can remember when I was in preschool, we had a pretend election. And it was the year when it was President Ford was running for re-election and Jimmy Carter was trying to unseat him. And I voted to keep President Ford. And I was the only kid in the class who voted for President Ford. And after that, all the other kids laughed at the Republican. But we saw how that played out over the next 4 years. I'm a Republican because the Republican Party is the party of freedom. I'm a Republican because the Republican Party is the party of the Constitution. I'm a Republican because our founding fathers implemented this country on principles of freedom and responsibility that are in this day embodied in the policies of the Republican Party. That's why I'm running as a Republican.
Thank you. This time we'll begin the next question with Andrew Hairston. And candidates all over the news, newspapers, television, the web, recent months, much to do about school safety, the Second Amendment, personal protection of the common citizen. And here in Alabama, there was a push to allow trained teachers to carry firearms or have access to firearms at school. Throughout our state and even locally, judges have armed guards, metal detectors, limited public access areas and entrances, along with well-funded security plans, and they are also allowed to personally carry a firearm with less restrictions than the average citizen. This is all for their personal protection. Considering these facts, please explain your thoughts on these important topics.
Thank you, Dan. That's a very important question. If judges sit in an ivory tower behind armed guards and metal detectors, why do the rest of us not have that? Well, we can't afford to have metal detectors and guards everywhere, so we have a constitutional right under the Second Amendment to a personal right to carry a weapon. And the Constitution says it shall not be infringed upon. I think allowing a teacher to have the same certification as my dad did as a police officer and carry a weapon is a smart choice. If the teacher wants to go get certified, the same certification, this is a post certification, if they want to go get certified as a police officer and carry a weapon, I think we should let them. Our children are sitting ducks in schools. I've got a child that's going to be in school in a few years. I don't want him being there and a resource officer because of funding being 10 miles down the road. The Second Amendment is a right guaranteed to all of us. A judge's #1 duty is to protect the Constitution. I believe in the Second Amendment. I grew up around guns, but I also respect them. A gun is not something we should throw over our shoulder and run through town and beat our chest over. It is a weapon. It can take a life. It's something that's very serious. So we need to make sure that we respect the weapon, but at the same time, not infringe on a person's right to exercise their constitutional right or to protect their family or their kids or their students.
Thank you. And Scott Lloyd, I would pose the same question to you.
Yeah, I am absolutely pro-Second Amendment. And I'll tell you, I learned some facts about the value of our Second Amendment a few years ago. I was the volunteer coach of the Center Middle School debate team, and we had to debate a topic about whether people should be allowed to concealed carry firearms. And during that, I learned about the research of a social scientist whose name was John Lott. Dr. Lott wrote a book that was called More Guns, Less Crime. And basically what he concluded after analyzing a large set of data was that the more legally owned firearms that are present in a community, the less crime is present in that community. And he specifically was for concealed carry because of the deterrent value of concealed carry firearms. Now the question I think was, should teachers be allowed to carry? I don't know that it was exactly worded in those terms. The Second Amendment is very important. Teachers have the Second Amendment right just like anybody else. And I believe that the Second Amendment is part of the Bill of Rights. It's part of our Constitution, and it's an important right. And everybody, including teachers, should have that right.
All right, and finally, Jeff McCurdy.
As I've stated, I'm pro-Second Amendment. Everywhere that I go, a gun goes with me. It's not on me personally right now, but it's in my vehicle. There's one on my nightstand. There's one in the closet. So I'm very pro-Second Amendment. As far as teachers being able to carry, what I would like to see to do is leave it up to the local boards of education and superintendent in that area. I'm not opposed to if they get qualified to use a firearm. I would not be opposed to them having them on campus. I think the thing that you might run into on campus is, what if that gun got taken away from them by a student? So I think that the safety of the weapon on campus would need to be looked at. But I'm not opposed to it. When the bill came out in Montgomery, I read it. It makes sense. I mean, we have guards at the DeKalb County Courthouse, and we don't have an SRO in every school. So I think that that's something that needs to be looked at. I don't know that there's probably no perfect scenario for this, but I think if they get qualified and they protect that weapon while it's at school from getting taken away from them, I would not be opposed to them carrying it on campus. Thank you.
All right, thank you, gentlemen. And our next question will begin, we'll start with the first order again. Scott, and then Jeff, and then Andrew. Explain your thoughts about the role of a judge in creating a civil and professional atmosphere in the courtroom as well as outside the courtroom.
There's actually a canon of judicial ethics that says that a judge is required to maintain the parties and the attorneys and other people present in his court to maintain a proper sense of decorum and respect for one another in the courtroom. And so the role that the judge has is to comply with that mandatory canon of judicial ethics and require the people who are present in his courtroom to maintain proper decorum and a civil setting in the courtroom. Now, the question also extended to outside the courtroom, and I believe that a judge should be a dignified person. And I believe that a judge should be a leader in the community in creating a dignified community. And as a matter of fact, I want to be cautious about saying something unduly favorable about a Democrat, but I will say that the man we're running to replace, Judge Cole, is a dignified man. I don't know anybody who doesn't think that Judge Cole is a dignified man. I think his personal dignity is a good example for any of us to follow in terms of how we live in the community and how we project ourselves to our neighbors.
All right.
I believe it would, the words that you would need to use in your courtroom is respect. Respect the lawyers, they're there to do a job. Respect the people that are bringing the cases. And even respect the defendants that are there as criminal defendants. You can send a person to jail for their wrongdoings and still be respectful. And so that's what I think you do as a judge. You just have respect for the people that's in your courtroom. I don't see that as a problem here in DeKalb County. I'm not seeing that as a problem. I think our judges are very respectful to the people that are in front of them. And on the outside, I believe you just show the people that you're a true leader in the community. And as a leader, that you're willing to do what you need to do to help the community. Whether it be in the court system or not, I believe that if you show people that you're a leader, people will respect you for that. And then again, when they come in front of you, they're going to respect you and your decisions that you make.
I have the privilege of serving as the judge for the city of Fort Payne and for the town of Geraldine. And so week in and week out, I get to go and serve those communities by being their judge. And I think the number one thing a judge needs to have is discernment. The law is the law. It's easy to find, especially with the internet and all our books are online now. The law is easy to find. But where's our common sense at, folks? Discernment. We've lost that in this country. The way you treat somebody is your ability to discern whether or not you need to be tough on them, whether you need to cut them a break. Monday night I put 3 people in jail. I didn't yell at them. I didn't cause a scene. But they kept doing things they weren't supposed to do, so we put them in jail. And I think the same thing's true as a circuit judge. People come into your courtroom and they're looking at you and how you conduct yourself as to how they're going to act. Not only the lawyers, but the defendant sitting there. And let's not forget, circuit judge also, about 65% of what a circuit judge does are civil cases. Domestic relations, divorces, custody, appeals. And so you've got people at the toughest time in their life going through a divorce, the breakdown of the family, that are before you. And if you come in there and treat them with respect and treat them like a human being, like you would want to be treated, a lot of times you can see the look on their face. They automatically calm down and they know you're going to make the right decision just by the way you treat them. And so I think it's very important to treat people like your mama used to say, treat them like you want to be treated. And I think if we had that in the world in general, we'd be better off, but especially in the courtroom.
Thank you, gentlemen. We move on to the next question, and we will go in this order: Jeff McCurdy, Andrew Hairston, and Scott Lloyd. Wide open kind of question here. Are there any types of cases you feel you would be unable to handle as a judge? And if so, explain.
I've been practicing for almost 9 years. I've handled speeding tickets to a murder case. I've handled all different types of domestic relations cases, from divorce to child custody to cases involving DHR. I've been a GAL for kids. I've handled multi-million-dollar estates, handled car wreck cases. There are a couple of areas that I have not handled as a lawyer, but I don't believe that there would be a case that would be so burdensome on me that I could not at least research it and get through that case. But I've handled, like I said, I've practiced in 11 different counties all over the state. So I believe that experience would allow me to handle most anything. And I'm not too big to go ask one of our other judges for some wisdom. You know, if a case comes before me that I didn't think that I knew a lot about. So I believe that humility would play a part in some of these cases as to whether or not you could handle. But I don't think there's a case that I wouldn't at least try to handle.
I was fortunate enough during law school in Birmingham to work for a very good firm in Birmingham. We had about 32 lawyers, and I clerked for Mark White, who's the past president of the Alabama State Bar. Augusta Dowd, one of the other partners at that firm, is the current president of the Alabama State Bar. And we had jury trials from Washington County to Marshall County, all across the state. Civil trials, criminal trials, in state and federal court. I've won a jury trial in federal court 2 years out of law school. And so there's not, between that and my law practice, I can't just sitting here think of a case, Danny, that I haven't handled. I've handled property tax appeals, divorces, custody cases, workman compensation cases, personal injury, juvenile cases, guardian ad litem work, and then on the criminal side, everything like Jeff said, from a speeding ticket. I've got a capital murder case in 2 weeks that I'm trying. And so I think the experience, the overall experience, a circuit judge is sort of like your general county judge, and they handle everything. And I think having that experience of handling everything in a bunch of different counties, seeing how judges do it all over the state, you can choose the good things that you like to the way each judge does it and apply those in your own courtroom. And so I think having that breadth of knowledge is very important. And just to frankly answer your question, I think on day one, I'd absolutely be able to handle any case that comes before you. And like I said earlier, just use discernment and common sense to apply the law to it.
We are running for the position of circuit judge, which is a very important position. You know, a circuit judge has to make literally life or death decisions. The circuit judge has to decide whether a death penalty case can be submitted to the jury for the consideration of the death penalty. It's a very important, very grave responsibility that a circuit judge bears. And, you know, I see Judge Bell and Judge Taylor sitting here, and I so admire them for the bravery that they've exhibited in being able to handle those cases. I'm the candidate here who has been on the legal team in the district attorney's office working on actual capital murder cases where the legal team had to go to court and ask a jury to impose a death penalty. You know, in the district attorney's office, we're the people's law firm, and we handle all kinds of cases. One thing that a lot of people don't know about the district attorney's office is that we handle a great many civil cases. As a matter of fact, I bet we handle as many civil cases as any law firm in this circuit. So in the DA's office, we've gotten experience with a great many types of cases. And of the candidates here, I believe that I am ready to go. I believe that I am ready to serve in the role of a circuit judge. I can't think of any type of case that I don't think I could handle. Because we're running for the job, I need to be prepared to do the job, except my wife is an attorney also, and I can't handle a case that she's a lawyer in or ever has been. That's the one type of case that I would say I don't think I can handle. Thank you.
Thank you. This time we'll go Andrew Hairston, and then Scott Lloyd and Jeff McCurdy on this question. And this is for all three of you. With a domestic relationship case, the goal is to be finished in 18 months or less. What steps will you implement to ensure this goal?
Well, first of all, in a domestic relations case, you've always got to remember you're handling a case where the individuals you have in front of you are going through the worst period of their life. And so the way you treat that is very important. The way that our judges do it now, Judge Cole, and I mean not Judge Cole, but Judge Bell and Judge Taylor, typically they will set it for a temporary hearing. And so what that does is it gives your lawyers a chance to come in and sort of talk and negotiate a little bit. And I think it's very important to allow the lawyers to do their job. They can get a lot of cases settled if you let the lawyers do their job. I think the worst thing a judge could do is come in and go, this is the way we're going to do it because this is the way I think. I think sometimes you set it for a temporary hearing, You let the lawyers come in, you let the parties come into court, and a lot of times you can get it worked out then. So setting a temporary hearing is going to be very important to get that case over with within that 18 months. The second thing is, as a judge, you work hard. If you've got orders, a lot of times lawyers file motions, and if you don't get an order for 3 or 4 weeks, that's 3 or 4 weeks you sat on the case and not been able to do anything. Now, luckily, in this circuit, we don't have that. And so that's something I would like to see continue, is when the lawyers file a motion, and there's a lot of motions in a domestic relations case. A lot. Probably the toughest cases you'll ever work are divorce cases, DR cases. And so having a judge that's on time, at work, works late, and get those orders out, that's a very important thing.
I agree that having hearings is important and getting cases cleared. Just from my work in the district attorney's office, I have noticed that sometimes the delay that comes into a case is just because there hasn't been court set in the case. And I have had the idea that if we could have hearings more often in cases, then you get the lawyers thinking about their cases. And to be honest, lawyers are like anybody else. Sometimes we put things off longer than we should, or until we absolutely have to deal with them. And so what I have noticed over my almost 22 years of legal experience is lawyers sometimes will work on their case either the day before they have court or the day of court. So there is great value in having more hearings because that gets people moving on their cases. That being said, in a domestic relations case, you're not just dealing with a case. You're dealing with people. And you're dealing with a marriage, and you're dealing with a family. While the goal is 18 months, I would hate for something I did as a judge to cause a marriage to become irreconcilably broken that could have been retrieved during the pendency of the case, a marriage that could have been saved where the parties might have reconciled. So in the course of meeting that 18-month goal, I sure would want to be careful about doing something that would drive the parties farther apart if that's a family that could have been reunified.
A lot of times what you see in divorce cases is the things that push them back and that cause a lot of delays is discovery. You'll have a set of questions or that you send to the other side, and they're supposed to answer them within 30 days. They're supposed to get them back to you, and then you send them the deal they're supposed to answer. Well, a lot of times they'll just kind of get to the lawyer and they kind of sit there. They don't get to the client when they're supposed to, and they don't get back to you when they're supposed to. I had a case in Baldwin County. When the judge gave us her first order, her preliminary order, she set out, you're going to have your discovery done on this date. You're going to have your depositions done on this date. If you're going to want mediation, you're going to have it ready on this date. And this is your final hearing date. Okay? And unless there is something that is utterly out of your control, your case is not going to be continued. I believe that that's something that could be implemented. A lot of times, as Mr. Lloyd stated, lawyers will work on it when they necessarily have to. So sometimes they may need a push. Not necessarily the parties that are in it, but also you got to look at, you're dealing with children a lot of times in these cases, and where they're going to go to school and who's going to pick them up when they're going to pick them up. So you got to take that into account. So I believe in keeping with an 18-month timetable, the judge can push things along and make the lawyers kind of get their work done a lot quicker.
All right, and we're going to kind of stay along the lines of divorce cases. And this time, Scott Lloyd, Jeff McCurdy, and Andrew Hairston in that order. And this is a multi-part question, so if you need a refresher, then feel free to ask. What are your thoughts about granting joint custody of a child to both parents in a divorce? Do you believe the parent should get an equal amount or as equal as possible with the children? Or do you believe the child benefits more by being raised by a mother or a father?
Okay, I want to be careful in answering this question because there's Canon 7 of the Alabama Canons of Judicial Ethics that provides that a candidate for judicial office is not supposed to talk about how he will rule on cases or what he will do in his official duties. I will say just generally thoughts about joint custody. joint custody often can be a very valuable solution. I have a very good friend, Marcy Foster, who is a lawyer who has pushed for that to be like a starting point. And I think there's nothing wrong with a judge generally having the view that joint custody is a good starting point, but if the evidence in the case shows that that's not the best situation for these children or for this family, then other arrangements would need to be made. All right, what was part B?
B was, well, about equal time amongst parents.
Okay, well, in terms of joint custody, I consider that the same thing. I just consider that the same
Right.
thing.
And then, so I would assume you do not believe that a child, or do you believe that a child benefits more with time spent with mother or father?
Well, I will say, I have had the good fortune that my family unit is intact. My wife Laura and I had our 20th wedding anniversary last summer. And we have twin girls, they're 14 years old. They are freshmen in high school. And I will say that certainly our children, because our family unit is intact, has benefited a great deal from having contact with both mother and father. And it would be hard for me to believe that that doesn't generally, for most children, continue to be the case, even when the marriage has been unfortunately dissolved. Okay.
As Mr. Lloyd stated, we're bound by not discussing how we rule on a case. In a divorce case, you just have to take each individual case on its face. You know, a lot of times in divorces, you'll hear what they call standard visitation. He gets standard visitation. I don't really like the word standard visitation because there's nothing standard about a divorce, okay? You have to take everything into account. What if the person works third shift? How can they get standard visitation? That's not going to work. So you just have to take each individual case and determine the facts, and the law that you use is the best interest of the child. It's not the best interest of the mother or father. Okay, you have to take into account what's the best interest of this child or these children in this case. And therefore, when you're talking about joint custody, and then you have what you call joint legal custody, and then you have true joint custody. When you're talking about true joint custody, that's 50-50. They're 1 week here, they're 1 week there. I think there was a bill in the legislature about making that starting point for every case. I'm not in agreement to make that starting point in every case. I think you need to look at it for every single case. And if it fits this case, then maybe it'll work. But like I said, you have to take every single case on its face. You have to look at all the facts, all of the background, and everything that goes along with it to find the best interest for these children or this child.
I think it would be a terrible mistake for a judge to go into a divorce case involving children with a starting point or a presumption on who they're going to give the child to. If we're going to do that, why have court? Let's just say if you get a divorce, the child goes here or there. That's why you elect us, is to make the tough decisions. But we're there. We see what's going on. We can send the parties for a drug screen. We can get evidence and testimony onto what did the dad do or what did the mom do. What's the criminal history of the mom or the criminal history of the dad? Do they have a good support system for daycare or child care if they go to work? I think it's a terrible idea to go into a case involving children with some preconceived idea of what you're going to do. The legal standard is best interest of the child. And I think it should stay that because the child's innocent. Whatever problems mom and dad are having, they're adults, they handle it. But that little baby, that little child is innocent in the entire thing. And I think it'd be a disservice to justice if the legislature did that. And I do oppose that. They're talking about making that a presumption. And in the legal world, a presumption is a big thing. And I think that's a mistake. One thing that is not used enough in divorce cases and custody cases is the use of a guardian ad litem. A guardian ad litem is an independent lawyer, a third party, if you say lawyer, that represents the best interest of the child. They're there to make sure the child's voice is heard and make sure that the child's getting what needs to be done for them. And so I think if we've got issues coming up on who gets custody, mom or dad, I say let's employ that a little bit more. But going into any case, I think involving a child with any starting point or preconceived idea is a mistake, and I would not do that as a judge.
And this order will be Jeff and Andrew and Scott. And we'll start with Jeff, and y'all have kind of walked around this one a little bit. And Jeff, you actually mentioned that you don't like the term standard visitation. And I know you couldn't see this from over there, but the next question deals with standard visitation. What are your plans for creating a standard visitation schedule for cases assigned to you?
Well, it's like I said, you have to take everything into account. If one of the parties works third shift, and you state that, well, they're only going to get every other weekend, Friday to Sunday, and then maybe a couple days during the week, how are you going to do that when they work third shift? They work third shift, they get off work, and they go home and they go to bed. When are they going to see their child? You're going to have to look at every single case. You're going to have to decipher between what works best for the child to see their parents, okay? I would, if every case could work out where they got equal time, that'd be great. But they're in a divorce, okay? They come to you because they can't make that happen, okay? They can't live together, apparently, so it's going to be hard for them to get equal time with that every parent, both parents. So, I mean, you have to just take it case by case, and you just have to figure out what works. I just don't think you can have a standard visitation and make it work for every case. I think you just have to look at all of the facts, their work schedule, like Andrew said, whether or not they have daycare, if they're at work, who's going to be watching the child, you know, things like that. And in every case, it's different. So I'm not a real fan of standard visitation, just having this week, you know, every other weekend, things like that. I think you just have to take it case by case, and you have to determine what's best in that particular case. And the next one come in may be totally different. Joint custody may work in that one, and you know, you ain't got a lot to do there. Every other week they go here and they go there. But you're going to have to take it case by case, and and not just say that this is what we're going to do as a standard visitation.
I'm not opposed to a judge having, which both of our judges that handle domestic relations cases have a standard visitation order. And I think that just sort of puts the parties on notice. If one party's awarded custody over the other, this is sort of what you're looking at as a visitation schedule. I'm not opposed to that. But again, the legal standard is best interest of the child. And that's the whole goal of having that standard. And so I don't think a judge should go into a case and go, okay, custody here, standard visitation here. We made a lot of strides. Standard visitation 10 years ago would have just been every other weekend. And now, most judges, their standard visitation is every other weekend, and then one Tuesday this week, and the next Thursday, and then one Tuesday, and next Thursday. And it gets really confusing for everybody involved. Every week I have clients call my office, go, is this my Tuesday? Is this my Thursday? Because neither side knows. And so I'm not opposed to a standard visitation order. I would have one as a circuit judge, but I think we can get together, all three judges, get the bar, get the lawyers involved, maybe get some community leaders involved, get DHR involved, people that deal with kids a lot, the Children's Advocacy Center. I think they ought to have a voice in it and go, okay, what works best for children? If we're not going to have week-to-week visitation, if we can't have that, what works best for children? Because you hear kids talk about, once they get 14 or 15, like, I hate packing up and moving every single week. And so I think if we can get the community involved and maybe get some ideas and get some help on how to best structure a proposed order, that would help us as well.
Scott?
All right. Again, I want to, like I said a few minutes ago, I want to be careful about answering this question because Canon 7 of the Alabama Canons of Judicial Ethics restricts what a judicial candidate can say about how he will rule on cases or carry out his duties. I see my friends Judge Bell and Judge Taylor sitting down here. They both have a standard visitation for their court. Standard visitation doesn't mean that that is the visitation they're going to impose in every case that they ever see. It doesn't mean that every divorce they ever see will result in that being the visitation order. What it means is it is what the parties probably can expect unless somebody shows them a good reason to do something different, such as the concern about somebody working third shift. So just because there's a standard visitation order doesn't mean that it would always be the visitation order in every case. A friend of mine, a domestic relations lawyer, specialist told me that the reason he's supporting me is, he said, Scott, the reason I'm supporting you is because I know that I will know what I'm getting with you. I will know that when I have a certain type of case, that you're going to give similar rulings on similar cases. And I think that it's important and valuable for the lawyers and the parties in a case to have an idea going in what is likely to happen, unless somebody shows the judge a good reason to do something different.
All right, and Andrew, you'll begin our line of questioning this time. And this is something that could possibly happen, and I would not pose it to the other honors here, but it's stuff that could happen. If someone from outside the courtroom contacted you and told you things about a case, how would you handle that situation?
Well, it happens. I have people, friends, people I went to school with, that call me every week about cases with Fort Payne or Geraldine. And I stop them, if I know where they're going, I stop them. I say, look, I can't hear that. I've got to rule on the case and be impartial. But if they start talking about it, and then you go, oh, I've got that case, you've got to recuse yourself. This is important. This is real life. This is people's lives that we're talking about. That's a huge responsibility. It's something that we should take very serious. And so just to frankly answer your question, if somebody tells me something about a case and I later learn that I am the judge in that case, or could be, or am the judge, or could be, then I would absolutely recuse myself, and I think any person with integrity would. And that's very important, is to uphold our system. You know, that's what makes us different than other countries. We don't go out and have duels in the streets anymore. We have a court system we can go to and handle our disputes, but you want a fair and impartial judge to hear the case, and you don't want a buddy calling him, somebody on the other side calling him and giving him some information. There's evidence, there's rules of court that you have to follow to make sure the judge hears what he needs to hear and doesn't hear stuff that may be hearsay or other things like that. So I think a judge should be very careful when he's talking about any case to make sure that it's not something that's beforehand.
I have seen judges handle that situation in this way. If somebody says something about the case, first of all, not everything that somebody might say about the case to a judge would necessarily be prejudicial to the outcome of the case, but assuming that something has been said to the judge that is prejudicial and that it's improper for the judge hearing that case to continue knowing. I have seen judges call in the lawyers for all of the parties and tell them, look, here's what has happened. My friend John Smith saw me on the street, didn't know that it was wrong to talk to me about the case, told me these facts, and then asked the lawyers and the parties involved, I will recuse if you want me to. Does anybody want me to recuse from this case? Now you at least all know what was said. Recusals don't need to necessarily be made sort of willy-nilly, because you can create problems for the other judges in your court or for other judges in neighboring counties even, if there are too many recusals from your case. Generally, I think that if there's been something said to the judge that is prejudicial about the case, then the judge needs to probably start with the proposition that he's about to recuse, unless all of the parties involved say, no, I know what happened and I consent to you continuing to handle this case.
I would agree with both of my colleagues. I believe if it's prejudicial or detrimental to the case, that you heard something about one of the other parties, I believe that you would absolutely have to recuse yourself. It reminds me of a case, I did my internship with Judge Whitmire here in DeKalb County, and we were in the middle of a case, and I don't remember if it's the plaintiff or defendant, had been going by a nickname, because here on the mountain and the valley, everybody's named Bubba or somebody, something, and that guy was going by his nickname. Well, one of the lawyers finally said the guy's real name, and Judge Whitmire had remembered that he represented this guy when he was a lawyer, and he stopped the trial right there. Said, I can't hear anymore, I don't want to hear anymore, I'm having to recuse myself. So I think that if something like that were to come up, either in the outside or like I just stated, if you're even sitting on the bench and you hear something that might jog your memory, I think you need to recuse. It's an integrity situation at that point. And one of the things I'm running on is fairness. And if you know something or hear something outside of it that wouldn't allow you to be fair, then you don't need to sit on that case.
All right, thank you, candidates. And Scott Lloyd will begin, and then Jeff McCurdy second, Andrew Hairston on this one third. And again, not wanting specifics, but there are several murder cases that are pending. What would you do to force, or what will you do if elected, to force the state to try the cases and ensure that the accused will get a fair trial? And will you allow the state endless continuances but hamper the defense in their effort to represent the accused?
Okay, well, I can certainly say the answer to that is absolutely not. I have been in your district attorney's office for over 21 years. And there in the People's Law Firm, that's been an honor to represent the people of these two counties and to help protect these counties from felons and help take criminals off the street. I do recognize that come January 2019, I will be taking off the hat of prosecutor and putting on a different hat, that of a judge, and my duties will be completely different. My duties will be to be fair and impartial to all of the parties that come before me, criminal defendants, as well as the DA's office. You know, my friend Judge Taylor here is a former assistant district attorney, and he ran for circuit judge, and he won. And I don't think that there is a problem with the defense bar thinking that Judge Taylor has been unfair to their clients just because he used to work in the district attorney's office. Your question was specifically about murder cases. I will say that in any case, the goal should be to get the case processed as expeditiously as possible. I will tell you that after over 21 years in the DA's office, what I have observed, and your question seems to presuppose that it's the DA's office asking for continuances in murder cases. It is my experience that generally it's the defense bar asking for a continuance. I'm not going to say every time, but to me, the defense lawyer has seemed to ask for continuances in the homicide cases more often than the district attorney's office.
I guess it's just in a fair trial situation.
Yeah, but I do completely recognize I will be assuming a very different role in January. I won't be a prosecutor anymore. I'll be a judge who has very different duties.
And of course, I'll be coming from the defense side, but that doesn't mean that just because I'm coming from the defense side that I'm going to give defense lawyers a break. I'm going to be fair to both sides. If there's a reason that a case needs to be continued, and it's a fair reason and reasonable, then it'll probably be continued. You know, a lot of times what you get is, even in some of these criminal cases, is a lack of discovery or something wasn't turned over at the right time. You know, I think that's something that could be handled better, and maybe a judge's order could do that expeditiously and get that rolling. But I believe that, you know, a lot of times what you have, it's not necessarily murder cases. You did use murder as their case, but it's the drug cases that are usually the backlog. And what you have with that is you have to allow that we're waiting on to get results from, whether or not it was a drug or not. And so I think that as a judge, what you want to do is you want to take both sides into account in a fair manner. And if one side or the other is not treating this case with respect, then you know you need to talk to that side and tell them, look, we're going to have this trial at this time, and you need to be ready for it. Like I said, I don't think you would say not to grant continuances if it's need be, but I believe that you could push it along and keep it on track in that manner.
Murder cases, and there's sort of two different cases. You've got capital murder cases in which the death penalty can be administered, and you've got murder cases in which you could have life or life without parole, but the death penalty is not an option. It is a huge, I support the death penalty. In a case where it is justified to use the death penalty, I do support it. But you've got to make sure that it's done the right way. You've got to make sure that they had a fair trial, because if it's the government taking someone's life. And so in that, sometimes the holdup is if you have to get a mental evaluation, you have to wait on the state to come in and do it. There's a lot of things on both sides, the prosecution and the defense attorneys, that cause the delays. The thing that I think can speed that up, in the death penalty cases I've had and in the murder cases that I've had, sometimes it's like there's nothing for you to go, okay, here's when this has to be done, this has to be done, and this has to be done. When I practiced in Birmingham, Danny, we had scheduling orders. So when you had a murder case or a capital felony case, the judge would issue a scheduling order. And what that was is it said discovery has to be completed by this day. Mental evaluations need to be completed by this day. If you're going to get a police officer to take your defendant to the scene of the crime, it has to be done by this day. And so what it is the goal was to get that case done within 1 year, which is a short amount of time in a death penalty case. But that scheduling order gave you something to make sure that you kept up with. And so that's something that I would like to work on, is getting a scheduling order in those serious criminal cases, because what that's going to do is going to put the prosecutor and the defense on notice. This is when we need to have everything done, and I think that would speed it up.
And this next question is multi-part, and Jeff McCurdy, you get the honor of beginning this round, and then Andrew, you'll be second, Scott Lloyd will be third. Drugs, we've mentioned that, a major problem in DeKalb and Cherokee County. Continue to get worse, it seems. Many don't know about the drug or the court referral system or the yearly contract in place with private drug testing and treatment industries. However, many are. And just briefly, what's your position on the current program? Is it really working? Just things of that nature. Are there any alternative programs that may get better results? And if you are in disagreement with the current system, how would you make plans to improve that?
Well, I believe that our court referral system plays a part in the court system, in that it helps keep track of the people that are either pending trial or that have pled into certain situations where they have to go to court referral. Is court referral a perfect system? No, it's not. I'll be the first one to tell you that. It's not a perfect system. There's not a perfect system for it. The system works if the person that's being treated by the court referral system wants it to work, okay? If a person wants to get help, it'll work. If they go into it thinking, well, I'll just do this long enough to get out of it and be done with it, that's not going to work. But that person's probably not going to work in any system. Now, Andrew's shed a little bit of light on this when he was talking in the beginning. There are some faith-based treatments that plans that could work. Again, if those people go into that just wanting to get out of jail, or just wanting to pacify the defense attorneys or the judges or the prosecutors, it's not going to work. A person has to hit bottom, and believe me, I've seen people that hit bottom. They're ready. He talked about the summit. One of the girls that graduated from the summit this couple weeks ago was my client. First one that got into the summit. For 3 years she was on the run. We couldn't find her anywhere. I told her, I said, one day they'll find you. They did. They put her in jail. She calls me. She says, I'm ready. I've hit the bottom. I got her in the summit. 1 year later she graduates. She's a totally different person. She's not the person that was running for 3 years. So it can work. There is some issues there that we could address. I don't know if there's a perfect system for it, but I would be open to different ideas with regard to that, though.
I do think that the faith-based long-term programs are the only thing that really work long-term. I'm not pushing religion on anybody. I'm not Bible thumping, anything like that. But I'm telling you, a person's soul is important. And until it changes, until their heart changes, until they don't want to be that person anymore and they want to be this person, 28-day drive facility ain't going to help them. But you get them there by saying, look, you can go to this treatment facility or you can go to jail. A lot of them will pick jail for a little while, and then the 2 meals a day and being locked in an 8x4 cell kind of gets old, and they'll call you. I mean, I can almost time it usually about 45 days to 50 days, and they want out. And then sometimes they're a little bit more humble, a little bit more meeker, and they want to go get help. The important thing, why is that important to a circuit judge? Well, court referral, they want to get people in to the faith-based programs. And you've got the Summit here in Fort Payne, you've got his place in Opelika, and Hosanna Home in Opelika. They run the biggest thrift store in the state of Alabama to fund those programs. And why are faith-based programs important? They teach you life skills. You can be sober and get out of treatment, but you don't have a job, you don't have somewhere to live, you don't have power at your house or water at your house. Those graduates from the Summit, they've been working. And the Summit took the money, they taught them how to balance a checkbook, so they've got a place to live when they get out. Their water's turned on, their power turned on, things that we take for granted, but when you're in the grips of addiction, you don't have that. And so that's the important thing. But court referral, their laws, their rules say they can't get you into a faith-based treatment unless a circuit judge orders it. When I became the judge at Fort Payne, day one, I issued a standing order that says, if you want to get into a faith-based treatment facility, court referral, I'm ordering you to get them in one. So they don't have to come to me. They don't have to sit in jail for a long time. They can get them in there. And I think that's something a circuit judge needs to do.
I would like to hear the question. The question was a little long. Could I?
It was a little, and it wasn't my wording, but anyway, drugs are a major problem. They continue to get worse. Many are not familiar with the details of the court referral system or the yearly contract in place with this private drug testing treatment industry. However, many are familiar. Briefly explain your position on the current program. Is it really working? Are there any alternative programs that have been addressed here that may have better results? Are the results of the current program acceptable?
Okay. I am the drug court prosecutor of Cherokee County, and I'm the only drug court prosecutor Cherokee County has ever had. I've been the prosecutor in that court as long as Cherokee County Drug Court has existed. I will tell you that what I have observed with the existing program is some people benefit from it and some people don't. We actually went to a training seminar to learn to be drug court prosecutors, and in that seminar they told us a good working definition of addiction is that it's a change in the person's brain that makes it easier for her to keep using than it is for her to stop using. And so the idea of the court system working on their recovery with them is to work on both ends of that problem. First of all, you try to change the person's, the fact that it is hard for the person to stop using by getting them into the treatment program, getting them into a residential treatment program if that's needed, or group therapy if that looks like it would suffice for that person. Additionally, you try to make it harder for the person to keep on using by making them go through drug testing on a regular basis, making them at least have to worry about the fact if I use today, I may get caught tomorrow. That makes it harder for them to keep on using. All of that is part of the existing court referral and treatment program that we have in the court system right now. And I have seen people who have achieved recovery, long-term recovery, and have been brought closer to the Lord during that process. So I can't agree that the existing program is completely meaningless or pointless or worthless. I do agree with my friend Andrew that faith-based recovery programs can be very important. They have great value. They treat the problem in different ways than other programs do. And I also attended the graduation for the Summit a couple of weeks ago, and I had a very different experience than what Jeff described. He described a client he had defended. I saw a young woman I had prosecuted, and I tried my best to send this young woman to prison. The judge decided that instead she was going to go to the Summit, and she went through that program. She received intensive help, and she graduated from that program a couple of weeks ago. And when I walked up to her at the end, I told her, "I'm proud of you," and both of us cried. That was a touching experience for me, very meaningful, and so yes, I completely agree that there are alternative programs that also can be valuable in the faith-based context. Thank you.
All right, we got a couple of questions here, and you probably don't need to elaborate as long on the first two. It's kind of a three-part question here, but we'll ask them individually. So the first two, we'll try to keep it a little shorter, although they are very important questions. And we'll begin with Andrew this time, then Scott, then Jeff. Question: what is your position on capital punishment and why?
I do support capital punishment. I support the death penalty. I think it is, maybe I got the question early, but like I said earlier, I do support it. I think it's something that's very serious. Growing up in a law enforcement family, when you have someone that has taken the life of another, and it's been proven that they did it with intent, it was not in self-defense, they've been convicted by a jury of their peers unanimously that they committed premeditated murder or murder with the intent to do it, I do think that the death penalty should be on the table. The way we do it now, to where you're convicted and then 30 years later you're put to death, doesn't work. It's not a deterrent when you wait that long. But I do support capital punishment, and I think it should be on the table. If you go out and take a life, we need to bring the hammer down on you, according to the law, apply the law. But there needs to be punishment for crime.
All right, Scott, same question.
I believe that in order to have a civil society, in order to have proper deterrence in a society, it is necessary to have capital punishment. Now, that being said, many years ago, I watched the commercials in a statewide judicial race, I think it was for state Supreme Court, where a candidate had an ad where he bragged about how easy it was for him to impose a death penalty when he was a circuit court judge. I'm going to say this. I believe that society needs the death penalty. I believe that a judge needs to be ready, willing, and able to impose the death penalty or submit a case to the jury for consideration of the death penalty when the case calls for it. But that is an awesome responsibility, and I do not believe that it should be easy. I think that it should be the hardest, most solemn, difficult duty that a judge ever has to carry out. But it is his duty, and he needs to be ready to do it.
I do support the death penalty. I believe in certain cases that it's warranted. I would go back to the most famous case probably in this county, Judith Ann Neely, 1982, I guess it was. There was a trial. It was determined that what they did to this young lady, just right over the road here, the jury came back, I believe, to give the person life in prison. And Judge Cole stated that, and he's actually, I've heard him say this, that if somebody deserved the death penalty, it would have been her because of what she did. I don't believe it should be taken lightly. You are ordering someone's life to cease, but in certain circumstances, it needs to be there. I would agree with Andrew. I think ones that happened in 1990 and they're executed in 2018, that's not much of a deterrent. And so that's where it needs to speed up in the appeals process. But I do support the death penalty, and I do believe that it's warranted in certain cases.
All right, thank you. Scott, we'll begin with you on this one. This is a fairly short answer, I think, or should be. When do you believe life begins?
At conception.
Let's see, who's next? That was Jeff?
At conception, no doubt.
And Andrew.
Danny, I agree, it begins at conception. And one of the most beautiful things I've ever heard, we went at, I think it was 8 weeks maybe, when Jessie was pregnant, and you hear that heartbeat. You can't tell me that's not a human being. I heard the heartbeat, and then life begins at conception.
And the follow-up to both of those questions, capital punishment and life begins at conception, as all three of you have concurred. How does one reconcile the differences between that? An outsider looks at it and they say, well, you're pro-life. Conception is when life begins, yet you take the life of an individual with capital punishment. How do you, in your own personal life, just kind of bridge that gap to where others outside of your life might say, well, there's a dichotomy there? Jeff is first. I'm sorry.
Well, when you're talking about life being at conception, you're talking about a baby who's innocent, doesn't have any choice whatsoever. And then when you're talking about somebody that's death penalty, you're talking about a person who made a choice to go and kill someone. They made a choice to either rob someone and they shot them or something like that. They made a choice. An adult made a choice. There's ramifications and circumstances that surround every choice that you make. And when you make that choice, then you have to live with the consequences. That baby, an embryo, does not have a choice. And therefore, that's apples and oranges to me. It's easy to explain. I'll explain it to anybody from New York that wants to come talk to me about it. But that's two totally different things. You got an adult making a choice to do something wrong that we know is wrong. There's nobody in here that would say that they believe murder is right, to go kill an innocent person. That's not right. So that person makes a choice. Therefore, there's a circumstance and there's punishment that goes along with that choice. The baby, on the other hand, does not have that same choice.
You know, morally speaking, I oppose abortion because I believe the Bible. I believe it's the Word of God, and it says that God knew you before you were in your mother's womb. And therefore, morally, I oppose abortion. But thinking of it from a legal standpoint, our Constitution guarantees that without due process, you can't be deprived of life, liberty, and property. I think the unborn child is just as entitled to due process as anybody. And so you can't legally, you're violating the Constitution when you have abortion because you're not giving that child due process. And so from a legal point of view, our Constitution guarantees the unborn child due process. And so so that child's innocent. But in a death penalty case, you've had due process. You've had a lawyer appointed for you. You've had a trial. You've had appeals after appeals after appeals. And so you've been found guilty. You're not innocent at that point. And so to me, there's a big difference there between being pro-life as far as life begins at conception versus also being able to support the death penalty. And I think you can do both.
All right, and finally, Scott.
Yeah, I think Jeff expressed this very well. The unborn baby has not had a chance to commit a murder. The unborn baby has made no choice leading to its death. Whereas a person who has been convicted of capital murder has chosen to kill, has been found guilty beyond a reasonable doubt by a jury of his peers, and has made a choice that has brought the death penalty upon himself. So you really, again, I again agree with Jeff, you just cannot compare the two situations. They're nothing alike.
Very good. You can breathe a sigh of relief. That is the end of the questions. So we just want to, as we wrap up, and we will go in reverse order. We went 1, 2, 3, and now we'll go 3, 2, 1. Yeah. So Scott, you'll begin, and Jeff, you'll be in the middle again, and Andrew, you'll go last. Just give a wrap-up closing statement, and include in that, why should people vote for you?
I'm Scott Lloyd, and I would like to be your next circuit judge. People should vote for me because when you go to the polls on June 5th, it is important to elect a judge who has the experience and the qualifications that these two counties need and deserve in their next circuit judge. I have almost 22 years of legal experience, over 21 of that serving the public in the People's Law Firm, the District Attorney's Office, taking felons off the street. That experience will serve these two counties well. So I would like to ask the voters on June 5th to vote for Scott Lloyd for Circuit Judge. And may I say in parting, we have a number of events coming up. We have one in Fort Payne on April 14th at 10 a.m. We would love for people, everybody is invited to that. We would love for you to come. We have one in Rainsville on April 17th. The one in Fort Payne is at 10 a.m. The one in Rainsville is at 6 p.m. The one in Fort Payne on April 14th is at DeKalb Republican Headquarters, 211 Galt Avenue North. The one in Rainsville is in the community room of the First Southern State Bank. Thank you.
Jeff?
My name is Jeff McCurdy, and I'm running for Circuit Judge. I would appreciate your support. As I stated in the beginning, I have a different background. I was not a lawyer from the time I got out of undergrad and law school. I had a different career through about 12 and a half years of that. So I think hard work is one of those things that you need to look for in a judge. I'm not discounting either one of my opponents for what they had to go through. Law school is tough for anybody, but I did work a job 40 hours a week and drive 186 miles round trip 3 nights a week to become a lawyer. So I would ask for your support I would ask for your vote on June the 5th. There could be a runoff. There's 3 candidates. It's very possible that that's going to happen. If that's the case, and I'm in the runoff, I'd ask your support in July. I can't remember that date, 17th, I believe.
Yeah.
We're having a couple of events coming up. April 26th at the Republican headquarters. We're going to have a meet and greet there at 6:30. Everyone's invited. And May the 3rd at 6 o'clock, we're going to have one over in Center at Bay Springs. And everyone's invited to that as well. We'll have some refreshments. You'll get a little bit more in depth of what I want to do for our communities, and be happy for anybody to come out and see us on that. Jeff McCurdy on June the 5th. Thank you.
Danny, thank you for doing this. I always like Danny's voice on the radio. I wish I had a voice like that. But, you know, thank y'all so much for coming out tonight, and for the people watching at home, thank y'all. Circuit judge is a big deal. It's a big deal. This is a big race. It's an important race. I think that the one thing that I look for in a candidate is being truthful, being honest, being themselves. The whole time we've campaigned, anybody that's helping me, I tell them, be yourself. One, if we get elected, we can't just flip and change and be somebody we're not. And two, I think the genuineness of a candidate comes through. And so I think that when you vote for somebody, you should vote for truthfulness. You know, our slogan is stand for good, stand with Andrew. It's a little cheesy, I know. Okay? But my mom came home last year and we were talking. I knew she wouldn't be here now, and I said, Mom, I think I'm going to run for Judge Cole's spot. And we were talking, and I said, what do you think? And she said, always choose righteousness over popularity, and always stand up for good. And that's why our slogan is stand for good. And I think that's what you want in a judge. That's what you want in any elected position. It starts with, we've got Mayor Abels from Geraldine here. It starts with the mayor and the city council. It goes up to the judges, the governor, the U.S. Supreme Court. We've got to start electing honest people that you can trust with the most important issues in your life. And one of our former presidents said, and it's one of my favorite quotes, politics is very rewarding. If you win, you can really make a difference in your community. And if you lose, well, you can always write a book. And I don't want to write a book. I want to win. But I want to win the right way. And I want to win by doing the right things. And I think our ideas work. We've seen them work at the local level. We've seen them work at Fort Payne and Geraldine. And I know they'll work at the courthouse as well. So I would humbly ask for your vote on June 5th.
All right. I want to thank all of the candidates for being a part of this tonight. It's great to hear the different views and different aspects. I want to thank the DeKalb County Republican Party, and also, of course, the Southern Torch, JSU Canyon Center. Don't forget, next week there'll be another primary candidates forum. That will take place at the Fort Payne City Auditorium at 6 p.m. So we hope you'll be there. I told you would have 2 opportunities to applaud, one at the beginning. This is your other opportunity. Let's hear it.
Thank you.